A new study on those who represent themselves in civil court has found the system works against them and they can face prejudice from judges and lawyers. Bridgette Toy-Cronin is a former lawyer whose PhD thesis at the University of Otago has looked into the experience of litigants who forego a lawyer in civil cases in the family, district and high courts. She says a lack of money to hire a lawyer is not the only reason, with previous negative experiences or a belief lawyers are unnecessary among the decisions to self-represent. But after talking to people who litigated in person, this is known as LIPs, as well as lawyers, judges and court staff, she's found there are significant barriers to someone's success in representing themselves in court, including getting the right information and advice on how the system works, and prejudicial views from lawyers and judges that the person taking the case is vexatious. Ms Toy-Cronin says while judges and court staff want to maintain the appearance that courts are accessible to ordinary people, much more needs to be done for this to be a reality, and a review of the civil legal system's needed. Bridgette's in Adelaide at the moment. Bridgette, good morning.
Good morning.
What are the reasons that people decide to fight cases themselves, despite obviously not, in most cases, not having had years of legal training? Why do they make the choice?
Well, the normal track is that people originally, in the first place, they will go to a lawyer. Most people do. But it's usually money which is the root of the decision. So civil legal aid is very difficult to obtain. The threshold for a single person with no dependents is $22,500, I think, per annum. That's the income threshold. So if you earn over that, you're probably not going to get legal aid. And then it's only a loan. You have to pay it back. And it's secured against your house if you have a house. So that can be very off-putting for people, or they simply can't afford it. But on top of that, the research I did found that there are a lot of other reasons in the background, people's perceptions of what the system's like and whether you really need a lawyer or not. Some of it was that they had had a bad experience with a lawyer, which might be either they perceived the lawyer was not competent for some reason, or it might be that they felt that the lawyer didn't give them a very high level of service. So it might be a very busy lawyer who sort of said, didn't make them feel like their case was important, or and so they thought, well, I may as well go off and do this myself. I'm not going to pay money to be treated like this. That was another aspect of it. There was also a perception that maybe you just go to court and you tell your story, the judge will listen, the judge will help. So you don't need a lawyer. Lawyers just, help you get through. They fill out the forms or tell you where to go. So there were those sorts of ideas. But the reality is that a civil court case is actually driven by the parties and by their lawyers. So you don't just have a job as a litigant to come and bring the facts to court. You also have to bring your legal case to court. So you have to bring the case law and the statute and argue all that in front of the judge. And I think a lot of people don't really understand how difficult that might be.
You mentioned civil cases, so this is different from criminal cases where someone is facing a criminal charge. Have you looked solely at the civil cases? And if so, in which courts and in what kinds of cases are they happening?
So I only looked at the civil jurisdiction. So criminal cases, obviously they get a lot more media attention, and there's been some recent high-profile cases where people have represented themselves in the criminal courts. It's different though, criminal, because that's you against the state. The state is looking to imprison you or punish you, and the legal aid that you get for criminal is different. So I didn't look at that. They're two fairly different issues. So civil is anything where you're disputing with another party. So it might be the government, it might be your neighbour, it might be your ex-spouse. So I was looking at family court cases, district court cases, where the maximum you can argue about in the district court is $200,000, and then over that you go up to the high court. And you might be, it might be your former business partner, it might be a contract, it might be a credit company, it might be a landlord, all sorts of things.
This perception, and I'm interested in what you found, that someone who does represent themselves is likely to be vexatious or litigious, was that an overt perception, or was it a subtle bias? What did you find?
It's more of a subtle bias. I think there's a lot of awareness within the judiciary and the legal profession that people are struggling to pay for a lawyer. They know that. But there's a very old saying which is very prevalent, both I found not just within the legal profession, but when I talk to people in the community, the idea that only a person who represents themselves in court has a fool for a client. This idea that you have to be kind of crazy to do this yourself. And within the legal profession, there's a lot of talk about the people who are what I've called persistent litigants, people who come to court over and over again, often for the same issue, but litigated in different ways, or some sort of particular issue that they're concerned with. And there is a real concern about those people within the legal profession. And I observed in the research that I did that often the conversation goes to that direction. People mentally start moving people into that category, and they're suspicious of them and concerned that they might be, abusing the court system.
What are the other barriers you found?
Well, a number of things which I think are just structurally make it difficult to represent yourself. So these people are often very smart and well educated, and they work extremely hard on their cases. But there's a lot of things that you need to be able to run a court case successfully. So you've got not just researching the law about your case, but you have to understand evidence law, which is a notoriously difficult subject. You have to understand procedure so that you can move your case forward and understand strategy. You have to know the etiquette of the court, how to address the judge, how to stand and talk, and all the things which are very fundamental to how our court system works. And then there's the aspect of the lack of separation between being an advocate and being someone who is emotionally caught up in a case, because it's your case, and even if it's not about the care of your children, which is obviously very high emotion, it might be about the future of your business. Those things are very, deeply felt issues. And it's hard for people to make judgments and retain that kind of emotional distance that you might need to say, look, this is a good settlement, or this is what we need to do next. And it's also very difficult if you are having to do evidence in court. So this is, cross-examination and examining witnesses, to both sit there and be cross-examined by the other party, and also keep an eye on your trial strategy and take notes. And you're basically playing two different roles that the system's simply not set up to have people play those two different roles.
What's your conclusion on it? Should it be that it's, basically where possible you should get professional legal advice, or is your conclusion in some cases it's financially not viable, it will cause people to not take cases that they should legitimately be able to take, and actually the system needs to flex a bit to make this more doable?
Yeah, so it's interesting. So the temptation is to say, look, we need to change the system to make it easier to use for people who are representing themselves. And we have done that in some ways, like we have the Disputes Tribunal, which is a forum where you have to represent yourself, and it's very informal. And then we say, well, do we bring that kind of trend right through our courts? My conclusion is that would not be a good idea, because the courts have a constitutional role to play. It's not just about private dispute resolution between two parties. It's partly about that, but it's not just about that. The courts are there to make precedent. So, our Parliament makes laws, those laws are written down, people use them, and when there's a dispute, it's the job of the courts to interpret what those mean. And in doing so, they are developing law. So we want people to come to court and argue important cases with lawyers so that we can develop our law. That's how our democracy works. So the question is then, how do you get people into court with lawyers? And I think that's probably where the system needs to change. But you can't just pull one lever to make that happen. It's quite a complex process.
Thank you very much. That's Bridgette Toy-Cronin, a former lawyer whose PhD thesis at the University of Otago has looked into the experience of litigants who represent themselves in court in civil cases.